You're going to kill somebody. You're going to kill somebody. And I can't do this. I wish I could.
Before we even get into this courtroom, you need to understand what you're about to witness. Because this isn't just a routine hearing. This is a full emotional and legal breakdown inside a courtroom where everything is on the line. We're dealing with a defendant already deep in legal trouble, prior violations, allegations of dishonesty under oath, and repeated concerns about alcohol use and compliance with court-ordered programs. And now the judge is at a breaking point, questioning whether honesty even exists anymore in this case. But here's where it gets even more intense. A sudden letter is introduced into the record, coming from a property owner completely shutting down any possibility of house arrest or tether placement. That single document shifts everything because it directly impacts where and how the defendant can serve any potential sentence. And as this unfolds, you'll see the judge go from frustration to full legal finality. No more warnings, no more chances, just consequences. But the real question is this: is the system finally holding someone accountable properly? Or are we watching a situation where circumstances are spiraling beyond control? Stick with this case until the end, because the final ruling hits hard, and it's not what everyone expects. This is where the case takes a sharp legal turn, because what the judge is reading isn't just personal conflict. It's a formal legal objection from the property owner. And in legal terms, this matters more than most people realize. When a defendant is being considered for electronic monitoring or house arrest, the proposed residents must legally consent. Without that consent, the court cannot simply force monitoring equipment onto private property. Now, listen carefully. This letter doesn't just deny consent. It revokes residency entirely, claims immediate eviction, and even preemptively blocks any attempt to use the address for probation compliance. That instantly creates a major sentencing complication. Because if the defendant cannot legally reside anywhere approved for monitoring, the court's options become extremely limited. So the question becomes, what happens when the legal system has accountability ready, but nowhere lawful to enforce it? This is exactly the kind of procedural roadblock that changes outcomes in real time inside a courtroom.
I am writing to you as the sole legal property owner of the residence located at. I'm aware that the defendant, Summer Greathouse, is currently serving a jail sentence under your jurisdiction and has an upcoming court hearing. Please be formally advised of the following. 1. No consent for tether/ankle monitor location. I do not consent to my property being used as a designated residence, base station location, or monitoring site for any court-ordered electronic tether, scram device, GPS tracker, or house arrest equipment. 2. Revocation of residency. Effective immediately, Summer Greathouse does not have permission to reside at, enter, or visit my property. Her residency privileges have been fully and permanently revoked. Formal eviction papers are currently being processed. Safety and security, that's number 3. For safety and privacy reasons, she will be barred from the premises immediately upon her release from the Wayne County Jail. 4. Clarification of child custody, rebuke of fraudulent claims. I am aware of the defendant's history of perjury and manipulation before this court. Specifically during her prior bond violation hearing, I'm advised she may attempt to claim her immediate release is necessary for child care. The children are completely safe, stable, and cared for in my custody. Her claims of child care hardship are entirely false. Because an alternative housing plan will be required for probation or tether compliance, I am notifying the court and the probation department in advance of her hearing so their defense counsel, Mr. Longton, can arrange an alternative location such as a residential facility, shelter, or different address that does not involve my property. Thank you for your immediate attention to this matter and for ensuring this notice is placed directly in her official case file. Respectfully submitted, Harrison Steves. So with that,
I can't respond to that.
you can respond whatever you want.
Because there's a lot of falsehoods in there.
Hang on a second. Hang on. You asked for a hearing. You filed a motion. I don't quite understand this. Let's go quite forth on it. That the court opined on the record that the defendant had violated her bond provisions by working in a restaurant that serves alcohol and not informing her probation officer about that employment. I had to go back and listen to the tape. I didn't say one word about that. What I did say is she wasn't truthful with me. What I did say is that when I asked if there was any material additions, corrections, or deletions, she should have been forthcoming. She should have been forthcoming with her probation officer. That's the only reason I scheduled this emergency motion for reconsideration of sentence, because that's just not true. I didn't say anything about bond conditions. I said she violated bond conditions in the past. She lied to me under oath in the first time she was drinking. She had 26 late sober link blows. She was positive for alcohol back in February 4 or 5 days in a row, 6, 7, 8, 9, and 10, I think it was, or February 8, 9, 10, and 11. And by the way, just to pile on here, she had to drive to court because somehow, some way, a car titled in her aunt's name remained in the parking lot for 2 days after she was sentenced. And by the way, I haven't checked it, but I believe she was still revoked. And this has been the pattern with your client. So you can correct whatever you want. I'm going to listen to you, and then we'll go from there. What do you want to correct?
She is a lawful resident.
That's fine. I'm not the divorce judge.
Well, what he's done, he's trying to take custody away from her. He's grabbed the kids, he's changed the locks. She's a lawful resident of that house. That address is on her driver's license. She has the right to go there. Please enter that house.
I just read you into the record. What he said. I didn't say anything was truthful.
Yeah, that's correct, John. You did not. But I wanted to make that clarification. I know my client is dying of me to address what you read in the record of that letter.
Okay, good enough. What else?
So what's happened is what I feared was going to happen. He's hired a new attorney. He's going to try to take custody away from her with an ex parte order because she's in jail. I have no defense to that as long as she's incarcerated. And she's been the primary care, primary custodian of his children since birth. The biological father, the temporary mother, has not been a primary caregiver, not been the custodian. And he's seized on this. We grab custody and I think the children are going to be harmed if we continue to keep her incarcerated. I have no doubt.
Is that you, Mr. Are you Mr. Steves? Are you Mr. Steves?
Yes.
Okay, he's in the back. Go ahead.
I have no doubt that these children are being harmed by taking away.
I'm not, but I don't have anything to do with it.
I know you must, but you certainly have a jailhouse that you can care to by her own. That's what I'm having. She has learned her lesson. There's no doubt in my mind she has learned her lesson both about honesty with this court and talking.
You can't lie to the court.
Your Honor.
I will not go through a sobriety court with a defendant who's lying to me left and right. And I gotta tell you, I don't know, maybe her aunt drove her here, decided to leave the car here and walk home and leave the car here for 2 days.
I doubt that. And you don't.
Your Honor.
It just underscores how she has not taken this seriously. Listen, I wanted to give you this hearing only because I wanted to clear up this record. I did not say anything about bond conditions. That is not a true statement, Mr. Longton. What I did say is she was not honest. I will let you speak for 10 seconds, ma'am, but you've got a lawyer representing you. This is a motion hearing. If you want to say something, you can, but go ahead.
Your Honor, when you asked me about the employment, I brought it up. I was unsure about bringing it up before that. I was desperate to just work for my kids. My kid's dad does travel a lot for work. I'm a mom. I wasn't sure what to say. You know, I wanted to bring it up. It wasn't something that was permanent. I want to complete this program. I want to be there for my kids. I enrolled myself in school. I've been going to counseling by myself. I understand that I made mistakes in the beginning, but I am more than committed and willing to complete this program if you would please just consider it. I'm a mom. I want to be there for my kids. I want to put this all behind me.
No, but you can't just say I can commit all these crimes and then say I want to put it behind me.
I will
This
not.
is the thing. This isn't a simple, isolated mistake. You've got 4. You lied to me under oath about your alcohol use. It's too much. I will not spend the twilight years of my career.
This is the turning point of the entire hearing, the moment where the judge stops evaluating explanations and starts evaluating patterns. What stands out here is not just one mistake, but what the court identifies as repeated dishonesty, repeated violations, and repeated failure to comply with sobriety and probation conditions. Legally speaking, judges in these situations rely heavily on credibility. Once the court determines that a defendant has been untruthful under oath or inconsistent with supervision requirements, it dramatically reduces judicial flexibility. And you can hear it clearly here. The judge is explicitly saying they will not continue investing time into a sobriety process that is not being respected. So when the motion for reconsideration is denied, it's not emotional, it's procedural. It's the court saying, enough violations, enough inconsistencies, final decision stands. Now the real question for viewers is, at what point does accountability become the only remaining option left?
I will
This is
not.
the thing. This isn't a simple, isolated mistake. You've got 4. You lied to me under oath about your alcohol use. It's too much. I will not spend the twilight years of my career trying to get people through sobriety court who are not being honest with me. I will not do that. I'm sorry.
Will
The
not
motion
have
for
a
reconsideration of the sentence is denied. I wish you well. I hope everything works out for you and your family. I really do, Ms. Greathouse, but I'm not changing my mind. Thank you all. Have a good day. But are you ready on short?
So here's how this courtroom case ultimately closes. The judge refuses to modify the sentence, citing repeated dishonesty, probation violations, and a complete breakdown of trust in the rehabilitation process. From a legal standpoint, this is a textbook example of how courtroom credibility directly impacts sentencing decisions. Once trust is lost in a probation or sobriety court setting, judges are far less likely to offer additional leniency, especially when prior warnings and opportunities have already been given. But beyond the legal outcome, this case raises a bigger question about accountability, rehabilitation, and whether repeated second chances help or enable further violations. And now I want to hear from you. Do you think the judge made the right call here? Or should there have been another opportunity given? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.